This episode of Off the Cuff is brought to you by Weaver Simmons, and we're very pleased to bring it to you. I hope you enjoy it.
Welcome back to Off the Cuff. This is part 3 of our series on how to start a case in family court and to do it yourself and represent yourself in the context of a family proceeding. So I'm hopeful that you enjoyed the first 2 parts. This is part 3, and I'm happy to be back here in the midst of what appears to be a crazy swirling scandal online about privacy and what you can do to alleviate some of your privacy concerns when you're attending public events. So I thought maybe I'd start with a little bit of the pop culture piece and seeing what's going on online. We'll get into the family law stuff, but what's more fun and engaging right now is the drama that's happening on Twitter, Instagram, and about this CEO who got basically shellacked for having an affair online. And what this came to me as was a privacy issue. And a lot of people are trying to figure out, when you attend one of these public events, what is your reasonable expectation of privacy? And it was interesting that, of course, everyone plays the blame game, and the CEO was blaming Coldplay for putting him up on the Jumbotron. And then you have the scandal of the girl who maybe paid off the people who were controlling the camera to put these 2 on camera because she knew what was going on. And so, the question becomes, where do your privacy rights start and end? Do you just inherently attending a public event waive your privacy rights? And if so, why? And really it boils down to the question, where do I have a reasonable expectation of privacy? The easiest one is in my own home. When you're at home, you have a reasonable expectation of privacy. And we can use this in the context of divorce in the sense that you hear of people installing cameras in teddy bears or nanny cams to watch what's going on in the house. And if it is that person's home, those videos are likely going to be inadmissible on the fact that they violated somebody's privacy rights. But if you're in a public space and you're recording, and in Canada, of course, we've done an episode on privacy. So again, you don't need 2-party consent to do that. And so you can record interactions and conversations. And a question I get asked a lot as a family law lawyer is, can I record exchanges? Can I record all of our interactions? Do I have to tell that person? And the answer is yes, you can. You can record it all. The weight that a judge puts on your recordings is going to be the real test and the real question. So as long as you can, with veracity, testify to how, when, where, why that video was taken, or audio recording for that matter, then it can be admissible as for the truth of its contents, not hearsay, as long as you, as the one party, were a party to that conversation. Where it becomes a bit tricky is if you're recording somebody else's conversation, and that is hearsay. And then you have to try to legally fit it into a hearsay exception, which we could go on and on and on about. But for the purposes of this episode, it's not super important. What you need to know is that in conversations that you are a part of and that are taking place in a public space or your own home, you have a reasonable expectation of privacy in your own home, and the other person entering your home does not have that same reasonable expectation of privacy. So again, if they're being recorded on audio or video without their knowledge, it doesn't necessarily matter. And same goes for the CEO drama. He's in a public space. And so to blame somebody else for putting a camera on him, well, it's kind of what you sign up for. And so our opinion, and again, we don't give legal advice here, is that He doesn't have any privacy rights vis-a-vis being at a public concert. And whether you're in a private box or whether you're on the floor, there's no privacy there. And so with that, I love doing this. I'm so happy to continue filming these episodes. I hope you guys enjoy them. And we'll take a quick break. And after the break, we'll get right into the actual content of this episode, which is learning how to start a family law case in the Superior Court of Justice. Stay tuned, and we'll be right back.
Make sure to like, follow, and subscribe.
All right, welcome back. And I want to get right into the reason why we're here is to learn how to start a case in Superior Court. So first I'll explain to you, of course, if you don't already know, the Superior Court of Justice in Ontario has the exclusive jurisdiction to adjudicate divorce cases. And collaterally to that is the jurisdiction to adjudicate on property issues. And property being money, real estate, pensions. That's all what we consider property in divorce. And that's how we determine what is called an equalization payment at the end of the marriage. And so, of course, again, if you go back to some of the episodes that we've done, we've talked about what equalization is, and what the common misconceptions of divorce are. And I'll just quickly go through that again. Most importantly, the biggest one is that everything is just split 50-50. And you'll see later on in this episode that that's simply just not the case. And I'll go through that with you because there are many scenarios in which stuff actually is not split 50-50 and why it makes sense, because it's truly just math and we don't have to be afraid of math. Sometimes it's ugly and sometimes it's not in your favor, but sometimes it is, and we just have to look at it that way. So first, let's get to how we get to that stage, which is the application for divorce. And there's a special form for that in Ontario. And you're looking at it. And if you're listening, I would encourage you to go online and pull up Form 8A, Application Divorce, from the Ontario Family Court Forms website, so you can follow along. Because you'll see as I go through this what matters and what's important, and why you fill this form out versus just having filled out a Form 8 General, which is what we looked at in the previous episodes to this series. So first things first, of course, that you, at the very top of the form, you're going to want to make sure you're in the right court and you have the right address. And as a tip to divorce, if there are children, you have to commence the case where the children reside. But in the scenario that there are no children, the divorce case can be started in either jurisdiction the party resides. That means that if you're divorcing somebody who lives in a different city, you can commence the divorce in your city, or they can commence the divorce in their city. But what matters, it's first in time. So if both of you start a claim for divorce, the one that started first in time is the one that ought to proceed. So that's step one, figuring out where, and that's where you live. If there are children, it's where they live. And that's the jurisdiction of the court to give them the ability to adjudicate on the dispute. So here, another piece to this is the top line. In this case, the applicant is claiming divorce only here, and you'll see that. And so sometimes people are just looking for a divorce, and they've sorted out all of the things and issues. Let's say the most common example is by way of a separation agreement, but yet they still have the divorce to finalize. So what we recommend typically is you start a claim in that scenario for divorce only. And then you would proceed in what we call in the legal world an uncontested divorce, which means that both parties are satisfied that they're going to get divorced. One person is starting the claim. They may share the cost or not, and that will usually have been decided by the parties in their separation agreement. And then you would click in this case, the applicant is claiming divorce only, and you would proceed just to get a divorce. And so if you have other issues that you've not settled, then you wouldn't checkmark that. And then as you go to page 2, there's another box that says this is a joint application for divorce. And typically we don't use that. So if you're listening to this or watching this and you are looking just to do a divorce, the best way and the easiest way is to choose the first option where one party's claiming divorce. The joint applications for divorce are not something we use very often, even if the parties are agreeable. You will also see here that both parties will need to fill out a form 13.1, which is something we're going to go through very shortly, to talk about all of your assets on the date of marriage, on the date of valuation, which fancy word for the date of separation, and then today's date, which doesn't overly matter a whole lot. As we progress through the application form on page 3, you'll notice that there's a family history portion. During the family history portion here, you're just going to fill this information out, everything that you know. If you're the applicant, of course, you're going to know your information, and the respondent is the other party, and you may not know their information, so you'll have to fill that in as you go. So here, applicant could be age 30, and, we can have the person born July 21, 1995, resident in Sudbury, Ontario, and then first name on the date before the marriage. And for consistency's sake, I will just put my name. And then because I'm a male, typically I will have the same last name as on the date before marriage. And then you see here the gender questions, divorced before, if you know the answer to that. And this is a new question: habitually resident in the province of Ontario for at least 1 year immediately before this application was filed. And typically most people in this scenario will click yes. This is for parties who have a foreign marriage, who are coming to Ontario. The court in Ontario wants to make sure that you've been a resident in this province for at least 1 year prior to this application, so that there's no issue or concern with the validity of the marriage, and then, of course, subsequently the divorce. Because the Divorce Act requires a person applying for a divorce to have lived in that province for 1 year prior to the filing of the application. And then we just continue on with the relationship dates: married, started living together, separated. So the date of marriage and the date of separation are very important here. So you want to make sure you fill those out properly. And I will say, actually, going back to page 1, a lot of people make mistakes on filling out the party names. You want to match here the exact names you see on your marriage certificate. So we're going to put our full names here and whatever is found on the marriage certificate, because the court cannot grant you a divorce if you don't have the same name as you did on your marriage certificate. And so a lot of people will in fact put their married names, and speaking mostly for women in that context, it'll be their married names that they put on the court forms. And in fact, what you must do is you must put your maiden name, or the name it was before you were married, because that is what you are essentially returning to after the marriage has ended and the divorce has been granted. Of course, you can keep your married name as a female who changes their name, or a male who changes their name. You can keep the married name to match those of your children. There's no legal requirement to change your name, and a court cannot order you to change your name back to your maiden name. And a lot of people will in fact keep their married name if they do have children, to make traveling easier after divorce. And so that's just a consideration you may want to have when you are traveling with children because it makes it easier to keep the same last name. But again, nobody can legally force anybody to change their name. So once you've changed it after a marriage, you can keep that last name, even if your ex-partner is insistent you change your name. There's no way they can force you to do so. Same with your children's last names. Once you've decided on your children's last names, both parties must consent to the children's name change. If you're hyphenating it after a divorce, there are processes to apply for name changes. There's a name change act, I believe, and there are requirements, and both parents have to consent to the name change, and that's often a term that we find ourselves putting in court orders or separation agreements to make sure that no one party changes the name of the kids. Especially in a sole decision-making environment, we still don't want the kids' names to change because that's their identity, and we take that very seriously. So those are just some considerations that you should look out for. Going back to the family history field, of course, here, if there are more than one child, more than one children, or more children than one, you would just continue to add however many kids, their birthdays, who they live with, etc., etc. Moving on to page 4, here you'll see if the parties have made a written agreement. So if there is a separation agreement, we'll say yes, separation agreement entered into on July 21, 2020. And here, of course, we're going to match our separation date of, let's say, 2019, so that then we entered a separation agreement in July 21st, 2020. And then has a notice of calculation or recalculation been issued? Typically, we're going to press no here. And here again, we're going to press no on if you're asking the court to make an order for child support that is different from the amount set out in the notice, which is referencing the notice above, which 99% of cases you're going to hit no on both of those. The next thing you're going to look at is the claims. So as the applicant, you're looking at claims under the Divorce Act. So if you're here in Superior Court, it's very important to press under this the claim for divorce. A lot of people either forget or just don't do that. Practically speaking, the court won't allow you to issue your application if you don't have a marriage certificate. So if you're looking for a divorce and you're starting a divorce claim, the very first thing you need to do is locate your marriage certificate. If you don't have it, you can order it online, and I'll put links below to the Ontario, at least the Ontario site that lets you order these online. And then you're going to file that with your application. Otherwise, the court will not allow you to apply for divorce. So sometimes out of expediency's sake, if there are urgent issues, you may elect actually not to claim for divorce, but you're going to claim for all of the other stuff, i.e. spousal support, support for children, table amount, decision-making responsibility for children, parenting time. Then we're going to skip the claims under the Family Law Act or the Children's Law Reform Act unless you're looking for a restraining order, because that order is made under the Children or the Family Law Act provisions. And here, if there's a declaration of parentage or guardianship over a child's property that you're looking for. But typically, the restraining order under the Children's Law Reform Act is the one that you would choose, and there's a fairly high threshold for doing that. And then you'll then move over to claims relating to property, equalization of net family property. So this is where the common misconception that everything is split 50-50, well, there's an equalization calculation, which we'll go through to see what that means by way of equalizing net family property. And then exclusive possession of the matrimonial home. If you want possession, let's say you are currently not in possession, but you're seeking to actually have possession of the matrimonial home to prepare it for sale or to move in because, for example, the other party is not paying the bills for the matrimonial home and you're paying the bills and you want to live there and they shouldn't be living there, then you would make a claim for what's called exclusive possession. And this is something the court can then look to order on an interim basis, that one party has exclusive possession of the matrimonial home. Exclusive possession of the contents of the matrimonial home is fairly self-explanatory. And then if there's any concern with respect to freezing of assets, so you'd be asking the court that nobody liquidate their assets. And then subsequent to that, you'd be looking at the sale of family property here. And so if you're looking for the sale of family property, that means you're looking for a claim that the matrimonial home be sold. And that's the most common, occurrence. If there's a matrimonial home involved, both parties are owners. And a caveat to that is that the matrimonial home specifically does not require both parties to be owners. The Family Law Act gives possessory rights to married spouses for the matrimonial home, whether or not there's only one owner to that matrimonial home. And so that becomes important for spouses who are not on title but are married. It protects their property rights. And that's why we do recommend looking at those issues, especially if you're planning on getting married or just planning on cohabiting and entering into a cohabitation agreement. You should have those discussions and think about those things early on in the relationship, because as time goes on and as money gets mingled, it becomes more difficult and much more painful later on if only one party is on title, but you've never married. And in Ontario, common law spouses don't have property rights. And so if there is no marriage and you're only together, only one person is on title, that can cause for some serious grief later on. In the context of divorce, obviously we're talking about a married couple, and a married couple, then each party has possessory rights over the matrimonial home regardless of ownership. So you're going to work through these claims if that applies to you. Costs, prejudgment interest, and then other, where annulment of marriage is not something we claim very often either. And we skip the part where we use this frame only if the applicant's only claim is for divorce, unless, again, this is a situation where you have settled all the issues and one party is applying for the divorce, and you would push that there. So that being said, we're going to take a break. Once we get through this next section, you'll be well informed on how to make a claim for divorce. And with that being said, we will see you soon. So this next part of the episode, we're going to take you through the remainder of the form to fill out on the application, and then I'm going to go through the 13.1 with you and show you what that looks like. So here we've found ourselves on page 5, the important facts supporting the claim for divorce. And so what we want to do here is where we would typically write in our facts that support the claim for divorce and also the other claims that we're making. So here we would typically say, my name is Chohan and the respondent and I were married on, and what have I put here? September 9, 2009. The respondent and I have separated on September 9, 2019. The respondent and I have one child of the marriage, namely born September 9, 2018. And so this is where you're going to just fill out all of the salient facts, your work schedule, proposed care schedule, spousal support, entitlement, etc. So you're going to write all that in this important facts that support your claim. And this sometimes can get very long and detailed, which it should, because this is where you are actually going to explain to the court what your claim is for. One thing we also do is we ask in the claim section for an order the applicant have sole decision-making responsibility for the child, namely a child born September 9, 2018. And so here, in this section, underneath the claims is where you're actually going to put all of the orders that you're looking for. If you're looking for spousal support, we would word it in a fashion like an order that the respondent pay to the applicant spousal support in the amount of whatever it is on a monthly basis pursuant to the spousal support advisory guidelines commencing on the first day of the month on August 1, 2025 and on the first of every month thereafter. So something along those lines is what you would craft, and as you can see sort of on the screen as I'm typing it here and just making it larger so you can read it. That's what it looks like there with respect to the types of orders you want. And this is where you're going to put orders related to parenting time, child support, Section 7 expenses, all of the things that you think you want a court to make an order for. This is the place underneath the claims where you're going to add those orders. And again, then under the important facts section, that's where you're going to put the important facts. Here, you cannot get divorced until you've been separated for at least 1 year. That's the law here in Canada. And I say Canada because divorce is federal and the Divorce Act is federal. And so it's not an Ontario piece of legislation. It is actually the Federal Divorce Act, which is Canada-wide. What we do not do is we do not award divorce or apply for divorce on the basis of adultery or cruelty, because in Canada we have a no-fault divorce regime, and it doesn't matter if somebody cheated. It does not change the calculation. It does not change the result. It does not change the outcome. And for cruelty or adultery, if you do choose divorce on those grounds, you do not have to be separated for a year, but you have to have a hearing on the issue and prove your case as to why divorce makes sense prior to the 1 year. Now, practically speaking, there's no way in hell you're going to get a court date hearing before a year on the serious issues of adultery or cruelty, because that's going to require a trial, and you're just simply not going to get a trial date within 1 year of commencing your claim. So practically speaking, we choose the separation route because 1 year post-separation, every couple is eligible for divorce. And so we just simply choose separation. If after 1 year's time, the parties are wanting to be divorced, we apply for divorce. If there's already a claim like this out there, we would apply for an order separating the divorce from the rest of the issues if it's important. So for example, this becomes the most important when one of the parties repartners and finds a new relationship. So that's typically why we would apply for an order separating or severing, is what we call it, the divorce from the corollary relief. And once that's done, then both parties are eligible to get divorced after the 1-year separation. And subsequent to that, they can deal with their other property and financial issues ongoing while they get their divorce and then remarry if that's what they're choosing to do, or just be divorced because it creates a level of finality and certainty for that person. And it's, of course, case specific. And you're going to want to evaluate if that's appropriate for you in that case. So once you fill that out, the rest is kind of done and takes care of itself. So you just, if you have a lawyer, the lawyer will sign the certificate. You're the applicant, so you're going to sign the certificate in where it says signature of applicant within the date. So you're going to sign that. Your lawyer, if you do have a lawyer, you're going to sign. Your lawyer will sign that section before it's filed. So that is essentially, as you can see, the case of how you would claim divorce. And now what I've done is I've also loaded up a financial statement. So we'll get to the financial statement so it's nice and centered on the screen for you. And in divorce cases, typically speaking, we fill out the Form 13.1. And so Form 13.1 is your property and support financial statement. And this is something that could be and can be overwhelming. I mean, if you watch the episode or listen to the episode on the Form 13, the forms are very similar but have differences in small distinct ways. So the financial Form 13.1 requires you to indicate to the court, and again, this is a sworn document which you have to sign under oath, that you are currently employed, self-employed, unemployed, etc., and you would choose the appropriate box. Then you're going to attach the appropriate pay stubs, employment insurance stub, statement of income. You're going to fill out your gross income from last year. So if you're in 2025, you would fill out your gross income from 2024, and that would be what fills that box in. And then you're going to confirm to the court that you're attaching the relevant documentation, being a copy of personal tax returns for the last 3 years, notices of assessment for the last 3 years, and then you're going to tell the court how much income you make and how you make it. So here, if we make $5,000 a month in employment income, and again, this is before all deductions, and if we are making $1,000 in commission, and we're receiving $2,500 in spousal support per month from our other spouse. This is our second relationship. So we're going to put all of that information here. It's very important because it gives the court a financial picture. Other benefits. This is where we would say house or work truck. This is your, Chevy work vehicle, and your yearly value is about $10,000. How we calculate that is what a monthly payment would be on that vehicle. Or alternatively, if your employer actually issues you a benefit that you pay tax on, like a work benefit that you pay tax on, we would put that there. So gas card, monthly gas expense. And we can say that our yearly market value, if we have, for example, $1,200 in yearly market value on our gas expense. So those are the things you want to look out for, and you are going to put those things there. Here also, sometimes we have stipend for remote living, danger pay. And there's a daily stipend with respect to danger pay, living in a remote location. And if that's worth, $15,000 a year, that's going to add to your income, and you're paying income tax on that work benefit. Then we move down to our expenses, and this is fairly easy. You can take the CPP contributions, EI premiums, et cetera, et cetera. You take this from a pay stub. So, for example, you'll see on your pay stub, okay, my monthly amount of CPP contributions is $150. My EI premiums are $100. I pay $2,000 in income tax. I have $122 of union dues. I pay $3,000 a month in rent. No property taxes because I'm renting. No property insurance. No condo fees. No repairs and maintenance fees. But I do pay utilities. So my water bill is $50. My heat bill is $50. My electricity bill is $150. I don't have a telephone, but I have a cell phone bill for $150. Pay $100 for cable and $50 for internet. My groceries cost me $800 a month. Household supplies, I pay about $20 a month. Meals outside the home, $100 a month. No pet care. I have laundry at the house. Daycare expenses are $500 a month. Babysitting costs are $0. Transportation, I don't take public transit. But I spend $200 in gas. My car insurance costs $145. Repairs and maintenance, car average of $150 a month. I pay $20 a month for parking, and my car payment is $569 a month. Health insurance premium is free. It's included with my employment. Same with dental expenses. I might spend $25 a month on medicine and drugs and $0 on eye care. Clothing, I buy myself about $150 a month worth of clothes. When you average it out, hair and beauty, $100. Alcohol and tobacco, $100. $0 on education, maybe $200 on entertainment, about $250 on gifts per month. My life insurance premium is $44. I don't take vacations. Clothing for children, I maybe spend $100 on clothing. Children's activities, about the same. Summer camp expenses are $500 a year. And so we've put that in. So you're going to go through that exercise. And then in part 3, we're going to talk about other income earners in the home. So here it's easy enough to say I live alone. But if you don't live alone, you're going to want to say, I am living with Jane Doe. And that tells the other person that there is a second person living at the house, which can factor into spousal support going forward. Here, of course, we updated this to 2019, so the valuation date is 2019. This is where it gets kind of confusing for people because they don't know what to write. So when you have a matrimonial home, 123 Solar Eclipse Way, Sudbury, date of marriage, obviously 0 because you own this after you got married. Valuation date is the value of the property on separation. And here, what we really need to do on the financial statement is be very careful because it says the market value of your interest. So if you think that your house on Solar Eclipse Way is worth $500,000, well, your interest in that matrimonial home is in fact $250,000. And if we separated in 2019 and we're 2025 after COVID, today our house might be worth $1 million. So our interest is $500,000 today. But let's also say first home before marriage, 1234 First Home Way, Sudbury. Now, this is where you're going to write, well, look, I owned a home before the marriage, before I moved in, and it was not Solar Eclipse Way. It was a different address, which is very important. And that house I sold it shortly after the marriage date because we moved into Solar Eclipse Way, and I sold that house for $300,000, very close to the date of marriage. So you're going to go through this whole exercise, household goods and furniture. This is where you're going to typically write big items, TV, furniture, kitchen, supplies, washer, dryer, etc. And for every item, of course, we're going to list every item and you're going to create, TV, bedroom furniture, 3 sofas, 2 kettles, 1 steam unit. And then you're going to say, okay, well, I moved out of the matrimonial home, but all these items are in the matrimonial home. You're going to say these items are not in my possession. And we didn't own any of this on the date of marriage, but on the date of separation, the TV's worth on Kijiji. Again, this is, as if you were fire sailing everything, $200 for the TV, $500 for the bedroom furniture, $1,500 for the sofas, $120 for the kettles, and particularly nice steam unit for $2,500. Cars, I own a Jeep, and the value of the Jeep was $20,000, and today it is now about $14,000. And so you're going to go through this whole exercise of things that you own. And again, you can always just continue to add different rows as you go on to do the calculations. Here, the bank accounts, savings, securities, and pensions. Just very quickly, you're going to, RBC checking, RBC joint account ending in 4567. On the date of marriage, this was 0. On date of separation, this was 4,500. And today it's 0. And then, RBC private account 4568. On the date of marriage, well, this had $20,000 on the date of marriage. On the date of separation, I had depleted it to 10, and after separation, it's now 0. And here, we're going to list out pension, Manulife account ending in 4321. And on the date of marriage, my pension was worth $150,000. On valuation date, it increased to $200,000, and today it's about $212,500. Another pension, RSP account ending in 1234. On the date of marriage, I had $180,000 of RRSPs. On separation date, look, I took out $100,000 of that, so now I'm left with $80,000 in my RRSPs, and today I'm left with a mere $15,000 after the separation because the money was needing to be withdrawn. So, as you can see, and then if you have investment, this can be with investors group, account ending in 9098. And then on the date of marriage, this was 0. But during the marriage, we built this investment up to $150,000, and today it's worth $175,000. So this is the exercise you would go through. Life insurance is self-explanatory. If there is a face amount, which is the cash surrender value, you would indicate it there. Business interests, again, market value of your interest. If you own a business, this is where that business value would go. Money owed to you, if somebody owes you money. Any other property, you would list it out. And then debts and other liabilities. So here we can take our example of matrimonial home and the other home, and we're going to match the debts here. On the date of marriage, of course, was 0. On the valuation date, your mortgage owing, and this here, notice you see it's amount owing. So this is the full amount because you are liable for the full debt. Even though it's asking you for your interest, you are still liable for the full debt. So on separation date, it was worth $150, and on valuation date, it was worth the debt is $125. Your only other debt is the home that you had here. On the date of marriage, this house was worth $300,000, as we said above, and the mortgage was very small, and you only had a $25,000 mortgage left on that property when you sold it. Valuation date is 0 and 0 here. Of course, for completion's sake, let's just put credit card, MasterCard, ending in 7654. And on the date of marriage, this was 0. On the valuation date, you owed $6,500, and today you've paid it down to $3,500. And let's say there's another credit card, Visa, ending in 7658. And on the date of marriage, you owed $2,500. On the valuation date, you owed $10,000, and today you owe $8,000. And so then we would just calculate. We have available to us what's called DivorceMate, which is our calculating software. So we type everything in and we can quickly calculate this. And so this actually shows here that this person's net family property is 0 based on all these numbers. It means that because of the deductions and because of the value of things on the date of marriage versus the date of separation and how everything played out, this person's net family property is actually 0. Meaning that when we do the net family property calculation, we actually then would end up, in theory, depending on who's keeping the matrimonial home, changing the value. So I'll leave it at that for now. That's a quick rundown of the financial statement. I know that was a lot. Thank you for sticking with me. Let's take a break and we'll close it off. Welcome back. That was a lot more than I anticipated. It does take a long time to go through these forms, so I do appreciate if you've made it this far, listening through to the whole thing and following along the way. The benefit of these episodes is you can consume them in small chunks and fast forward, rewind, slow down what you missed or didn't miss, and go back to see what is important in these forms. And reading the forms really matters. And so what I encourage you to do, if you are trying to self-rep through this process, and it's very difficult to understand these concepts, is get legal advice. At the very least, have somebody review what you've done. So if you do fill out these forms, pay a lawyer to review the forms for you. Talk to a family law mediator that may understand these things, and just be informed. A lawyer is just a phone call away, and most lawyers will happily take a small retainer to review documents if you can, get help for resolution purposes. We're always open to that. A lot of people think that we're very expensive and we're not worth it and we don't understand what we're doing and you can do it better than us. And my response to you is maybe you can. But we've been trained in how to do this, and we've been trained at how to negotiate and to point out things that you may not necessarily feel are important. That's our job to do. And so, well, it's great to fill these forms out. It is also great to have a second set of eyes on them, but I'm doing this for the purposes of helping you, the listener or the viewer, fill these forms out yourself and get a head start, or at least understand why you're doing what you're doing. So it was a pretty long episode. I don't want to keep you much longer. Follow us on Instagram. Take a look at our YouTube channel. Like, follow, subscribe. Keep watching. Keep staying tuned. There will be another part 4, explaining the net family property statement and probably speaking about the answer. So if you're ever served with documents, what you do, and the timelines in that you are allowed to respond. So I will leave you with that. This has been Off the Cuff. My name is Darren Chohan. Thanks for tuning in, and we will see you next time.